Welcome to Channel 17, the Town of Colonie Government Channel.
Hello, I'm Colonie Town Judge Peter Crummey, and welcome to Benchmark. We'll explore a variety of issues involving our justice system, our legal system, and how they intersect with the citizens of the town of Colonie. Today, we are so truly fortunate to have one of our area's premier attorneys join us. In fact, not only is he a premier attorney here in the Capital Region, but I dare say in the state of New York and in the United States of America. Please welcome our guest today, Stewart Jones. And hello, how are you?
Peter, thank you for that generous and probably exaggerated introduction. I appreciate it.
Well, we're so very fortunate to have you here today, and as a Colonie Town resident, we're all so proud that you've made so many contributions, not only to our town, to the Capital Region, but also to the legal system in the state of New York. So many landmark cases and involving both civil and criminal issues. And I know everybody's so excited to hear from you today. How did you get involved in the practice of law?
Family firm, came out of college, wasn't sure what I wanted to do, decided to go to law school because I knew if I liked law school, I would have an opportunity to go to the family firm. Law school and I got along very well, so it's worked out nicely for me. I've had wonderful opportunities, have had opportunities earlier than most lawyers have. And it's all because of the firm, my father's name, my grandfather's practice, and a lot of good people and mentors along the way.
Now, early on in your legal career, you didn't spend all of your time with the family firm. You spent some time pursuing municipal work as well, government work. What was that?
I came out of law school and went into the district attorney's office in Rensselaer County. Con Chalax had just been elected district attorney in Rensselaer County, and I was able to join that organization right up front with him. He was a wonderful man, became a fabulous judge. But he gave me opportunities. 1 year after I had joined that organization, I was prosecuting murder cases in Rensselaer County. And that was because he let people develop, he mentored them, then he gave them the opportunity to do it themselves. So I learned a tremendous amount in that 3 years I was with him. Had opportunities that I wouldn't have gotten until I was 10 or 15 years out of law school if I had not been in that office. So really was something that transformed my life and gave me opportunities that I think I was able to build on through my father and the father's firm. So I've been blessed from the very beginning.
Well, your experience in the district attorney's office, of course, provided you with tremendous courtroom experience, but you haven't always spent all of your practice on criminal cases. You've also been involved in a variety of civil cases over the years. Some are noted landmark cases and that have been celebrated cases throughout, and law students routinely are asked to learn about particular cases that you've been involved with. And I think early on there was a case involving Chrysler Motor Corp. And a products liability case. Could you tell us a little bit about that case?
Yes, and a lot of people think that what we do is criminal law because they see my name in the paper in association with high-profile cases. Right. But 70 to 75% of our work is in the personal injury wrongful death litigation field. And in this particular case, Caprera against Chrysler Motors, there was a trial in Rensselaer County that involved a defective ball joint. There was an evidentiary issue as to whether or not changes in the way in which the joint was manufactured should be received when those changes were post-manufacture. The law in the state of New York and the law nationally was adverse to the admissibility of that evidence, which was critical to the success of the case. Judge Travers, who's now deceased, but he allowed that in evidence. The case went to the Court of Appeals. The Court of Appeals, in a 4-3 decision, which is very close, obviously, changed the law in New York, sustained the admissibility of that evidence, and that became a bellwether case nationally. It transformed the products liability field and allowed the admissibility of post-accident, post-manufacture evidence into the proof that the jury was hearing in order to make the decision. So it's still good law today, still referred to today, and it's certainly one of the cases that our firm is proudest of.
And certainly, too, the purpose behind it was to right a wrong. Isn't that the whole theory about being representing plaintiffs in civil matters?
Our practice is about that. We believe that we represent individuals, we represent families. 99.9% of our work is on behalf of individuals and families, and we are in the business of trying to remedy injustice, to right wrongs, and to secure some degree of quality of life for the people who've lost it as a result of the negligence of others. So that in the Capera case specifically, he was a quadriplegic as a result of the failure of that vehicle and the defect that produced that failure. And we've represented quadriplegic, paraplegic, brain injured adults and children. So we think we're doing the kind of work that benefits society and certainly, re-alters the balance in the lives of people who've been so badly harmed.
Well, you've certainly touched on another issue as well about your practice, and that's the criminal practice. And obviously, you've been involved in many notorious cases throughout the state of New York, and so many people have benefited by being able to be represented by you in a variety of matters. And I bet there's some cases that you have been involved with on the criminal side, which also created a change in law or provided a landmark a designation. Any of those out there in your criminal practice?
I think the two most significant areas are in the jury selection, which is critically important in both civil and criminal cases, and in the representation of clients in a criminal case. I've gone to the Court of Appeals a couple of times on jury selection issues in criminal cases, and we have changed the way in which judges must look at challenges to the qualifications of a juror for express or implied bias. In the cases I'm talking about, we were talking about part-time police officers or a juror who had an experience that was specifically relevant to the subject matter of the trial. We challenged that juror. Judge denied the challenge. We had exhausted what we call our peremptory challenges, which is the type of challenge where you can remove a juror without a cause. We had the convictions resulted. We go to the Court of Appeals. The Court of Appeals said the judge was wrong, that in those circumstances there is an implied bias present and the cause challenge should have been granted. In the representation of individuals, we really have altered the balance because it used to be that you would see a lawyer representing 2 clients, 3 clients. And the end result of that, of course, is that at some point in time a conflict develops and one of the clients is sacrificed to the best interests of the other. I've gone to the Court of Appeals on that issue, and the Court of Appeals basically said that only in extraordinary circumstances, after an exhaustive inquiry by the court, can a single lawyer represent more than one client where both clients are charged with identical crimes.
And I've been practicing 25 years, and you over 40 years, and certainly that concept is so black and white now for attorneys as they move forward, to the extent that there are often times as Colonie Town Judge that I need to appoint, there's multiple defendants and they need to be represented either by a different counsel. In fact, the county has tried to address it even at the public defender level by creating a conflict defender's office. And then there are also assigned counsels that I often have to do because there may be 3 or more defendants as well. And that's had a dramatic impact on, certainly, to the rights of the defendant.
It's much for the better for the justice system. There is never equal guilt among all parties in a given case, so each one should have individual representation so they can be individualized and treated specifically in accord with their respective role. You have one lawyer representing everybody, that doesn't happen.
Now, I know many people are very interested in your view of how the practice of law has changed during your time practicing. And I often routinely hear from attorneys who will tell me that there's less camaraderie among attorneys or less opportunity for attorneys to meet and greet each other. And I was wondering whether you feel that's true and whether that's had a negative impact on the practice of law.
There are far more lawyers, but you have contact with far fewer lawyers. You don't know as many lawyers. You don't have a collegial relationship with as many lawyers. The advertising has altered the balance in our profession. We have an incredibly competitive profession today, which has reduced the collegiality. You don't have what we call special terms, which were gatherings of lawyers before a specific judge for a calendar reading or for the argument of motions. We've depersonalized the law. We've taken opportunities for young lawyers away from them to argue motions, to try small cases, to get their feet wet and develop a presence in the courtroom and have some experience in the courtroom, whether it's arguing motions or trying small cases. There are no more small cases. So young lawyers don't get a chance to try cases because clients don't want young lawyers trying big cases, whether they're insurance companies or corporations or individuals or families. They want the top dog trying that particular case. You don't have an opportunity to argue motions anymore. When I started practicing law, the senior lawyers would send the junior lawyers in to argue the motions that are associated with the case, and that's a very good way to learn to think on your feet, to engage a judge in back and forth dialogue, and to learn something about arguing and analyzing. Most judges now don't entertain oral argument, so everything is done on paper. The amount of paperwork that's required today is absolutely crushing, and that's a dramatic change in the way we practice law. I used to be able to go to a courtroom for conferences, and I'd have 6 files with me. Today, one case takes up 6 or 10 Redwells, so it's a much more complicated process. It's a more impersonal process, and there's far less opportunity for lawyers who are starting out today to get experience quickly and to have opportunities that I had at a very early age. It's simply not possible any longer.
Well, you've raised a good point, because it seems to me that typically at the Supreme Court level, there really the opportunity for oral argument is nearly negated, and it's only at the appellate division or beyond that you actually have an opportunity to speak on your feet. So many of the matters are done, as you said, on papers. Everything's sent in, and then a decision will be forthcoming, but you may never have even met the judge who is deciding the case.
That's correct. And there are far fewer trials today. The litigation process has become so paper-heavy and time-consuming and expensive that there are far fewer trials. The opportunity for jury selection, both in civil and criminal cases, has been so limited and time narrowed that people are more afraid today of juries than they have been in the past, and aren't willing to entrust the decision that may impact the balance of their lives to a juror. So you see a lot of mediation, you see a lot of arbitration, you see a lot of decisions that are made by judges. The process has changed. It's no longer a jury determinative process. It's now a process that relies heavily upon decision-making by single individuals or through a mediation or arbitration process.
Well, you've raised a very salient issue concerning finding the truth, which is what I believe I'm charged with. You must find the truth. And oftentimes, jurors are asked to be the trier of fact. And I think you've just told us that actually the opportunity to have the best jury deciding that issue of fact is much more limited today, and actually may not, and as a result may preclude the opportunity to find the truth. What is it now? How's it working now as opposed to how it used to work?
I'm a very strong believer in the jury system. I mean, the jurors are the reasons I've been successful. They've been very good to me over 40 years. But today, the law has changed so that we have very little time, whether it's a civil case or a criminal case, to spend with the jury in the jury selection process. The judges control the questioning in criminal cases, then they turn it over to you for maybe 15 minutes to talk to 22 jurors, and then 10 minutes the next round to talk to the same 22 or a different 22. So you don't have an opportunity to learn who the jurors are, to engage the jurors, to explore their experiences or the experiences of their families. We all are creatures of the experiences that we've had and the experiences our families have had, and they influence the way we look at things. And if we don't know how a juror's experiences have influenced their perceptions and create the context within which they will decide cases or reach decisions with respect to fact determination, we are really trying the case in the blind. And that is what is happening both civilly and criminally. We are spending so little time in the jury selection process, for the most part, that we aren't getting the right juries for the right cases. There are jurors who should sit on a particular case because of their experience. There are jurors who shouldn't because of their experience sit in that same case. We don't know that as well as we once did. It used to be that you could take days to pick a jury in a civil case, weeks in a criminal case. I tried a celebrated criminal case in Rensselaer County 15 years ago, the John Romalo murder case, where he was accused of murdering his wife through the administration of chloroform. He was a town Greenbush town councilman. It was a highly visible case. Andy Dwyer presided over the case. We spent 3 weeks getting the jury in that case. And it was a case that required 3 weeks because it received an enormous amount of publicity. There was deep passion in the community about the case. And if it hadn't been for that opportunity, we would never have gotten the jury that would have objectively looked at the science and the medicine and the facts and come to the right decision. So it's critically important, and one of the reasons I think that we're seeing fewer jury trials is because people are afraid to entrust the case to a jury because they don't have enough opportunity to spend with the jury and learn something about the jury. So they go to what they know. What they know is an arbitrator they agree on, or a mediator who they both know, or a judge who they're familiar with. It's just they aren't willing to roll the dice with a jury that they don't feel will ever be able to get to know well enough to entrust an important case to.
Do you think that that result is also promoted by by court administration, knowing that jury trials can take significant time, that there may be an effort by administrators to have fewer jury trials because of the commitment it takes, not only for the courtroom, but for the judge and for a variety of staffers as well? Do you think there's a underlying movement to have fewer jury trials?
Many judges, particularly those who have not had extensive trial experience, hate the jury selection process. They feel it's a necessary evil, that it takes time away from the meat of the case, which is the presentation of the evidence. But I think in large measure it's being driven by a mindset at the administrative level for the court system, and that mindset is influenced principally by the New York City experience. A lot of decisions are made at the judicial administration level that are influenced by the unusual way in which law is practiced in the city of New York, and that has no relevance to the way in which we practice law upstate. We are a far more collegial, trusting process up here, and we don't abuse the system. In New York City, there is a lot of abuse, and that has led to some of these restrictions that are being applied statewide, even though they are relevant to New York and not relevant to the upstate experience.
Well, you've mentioned as well that another problem that you're seeing with the ability to proceed in a jury trial is the expense, not the court expense necessarily, and of having jurors and staffers and court reporters, et cetera, and the judge's time as well, but actually prosecuting a case, a civil case, is demanding, is very expensive to do as well, experts and the like. Do you see that that's changed dramatically over the years?
Yes, we are an expert-dependent litigation society. Every case requires an expert. Even the simplest fall-down case requires an expert. It may be a civil engineer. All cases involving personal injury or wrongful death require medical testimony. Medical testimony is very expensive. Doctors don't have the time any longer to participate with their patients in this justice system. They are reluctant to come to court. They charge you a fortune in order to deter you really from asking to come to court. But these cases have to be tried or have to be resolved, and you have to pay the money. Ultimately, that comes out of the client's recovery. So the cost of doing business in civil cases as well as in criminal cases has become prohibitive, and it's really changed the way in which the practice exists, because you have to have a firm who can bankroll these cases, because the clients certainly can't. They can't pay $10,000 or $25,000 to an expert to come to testify. In some malpractice cases, we're paying $25,000 to these nationally renowned specialists to come in and testify on behalf of our clients. Unless you're representing a Rockefeller or a Trump, that's not possible. So the firm has to be able to bankroll that, which means that the opportunity for a small firm or the solo practitioner to take these cases on is gone. In the criminal field, because of the CSI effect, prosecutors feel that they have to have an expert come in and explain why there may not be any scientific evidence in the case. Defense lawyer says, well, I'm going to have an expert say that there should be CSI. Now, these cases would have been tried without experts at all 15, 20, 25 years ago. And now, even in the criminal field, you're required to bring in an expert to explain the presence of or absence of evidence that jurors have an expectation should be there because they believe what they see on television. Television has a profound impact on the way cases are perceived by jurors today. There are so many shows on television today that deal with the legal system and the litigation process, both criminal and civil, and this has an impact, even though it's a complete distorted perception of the way in which cases are resolved and the way in which the process works. Jurors come in with a set of expectations, and those expectations either have to be diffused or they have to be met. And if you don't have time during the jury selection process to deal with the whole issue of expectations, and you usually don't, then you're in a very dangerous position of having to be able to meet those expectations, which becomes inherently costly and even though unnecessary.
I've found that TV has a pronounced impact on my own caseload here in the town of Colonie. We have a very busy court handling over 25,000 cases a year, and many cases are small claims, small civil matters. And you can't turn on the television today at 4 o'clock in the afternoon and not see 4 or 5 what would appear to be small claims court cases. But I try to encourage people who are in my courtroom that that's not the way it works. And those people have won a trip to Disney World so that they can go down and express themselves oftentimes in ways that would not be allowed in a real courtroom. But I'm oftentimes afraid that people get a notion about what court is by watching various shows on television, which are really more game show than reality. And I do think that it has an impact on what people perceive to be court.
Yeah, the way in which we live today creates all sorts of external filters through which we perceive things. And if you're not in tune with that when you're in the courtroom looking to pick a jury and try your case, you're going to get a juror or jurors whose experiences are such that regardless of what type of case you present, they're going to apply their own standard. And the instructions from the court are not going to dilute that or alter it, and that's why the jury selection process remains critically important.
Now, your firm has been very successful over the years in a variety of matters. Are there cases that you turn away? If somebody brings you a case and you decide, do you routinely make decisions on not taking a case or not offering representation?
Have to. You can't take everything. We're a relatively small firm. We've always been sort of a boutique operation. We've never had more than 6 lawyers. We have 4 lawyers now. So we are highly selective. We have to be. We probably take about 1 out of every 20 medical malpractice cases that come to us either directly or through referral. We have a huge referral practice for medical malpractice cases throughout the state of New York. But you can't represent everybody, and you should only represent those who you can represent fully and well and to a conclusion. I mean, every case that we take, we prepare as though it's going to trial, even though ultimately overwhelming majority don't. You still have to prepare for that, and you can't do justice to the clients that you have if you're representing too many clients. So unfortunately, you have to be selective, and we believe we're doing a favor to those people that we do turn away and point in a direction that will enable them to be more timely and better served.
Now, you find yourself involved in courtroom activity routinely and on a regular basis. And there's been much talk about the New York State judicial selection process. And I believe there was some litigation pending asking the federal court system to look at the New York system as to how Supreme Court judges are actually picked through a delegate process, typically, that we've had here most every September when there's a vacancy to be filled, as opposed to a petition process, which is how I'm selected. You have to go out in the summer and have signatures signed to get on a particular ballot line, and then you're on the ballot in November. But Supreme Court judges are chosen differently so far. And one of the challenges to the current system is that it doesn't really provide for community input. Do you think over the past 40 years that you've seen that system work or sometimes fail, or be no different or better than having a petition process where people have to go out on their own and go to a 7-county area, for instance, and get signatures and to try to get on the ballot that way?
I think the petition process works very well for local judicial races, but to expand that to the geographical reach of, for instance, the 3rd District, I think be very difficult and very costly. The way the system works now here obviously can be improved on, but it's worked well. We have a very solid bench. We have a lot of good judges, both in the 3rd Department and 4th Department. The real problem exists in New York and the 5 boroughs there and Long Island, and that has led to this drive by the Court of Appeals and the administrative judges to alter the way in which things are done. But again, that's the impact of bad experiences in New York. New York everything is highly politicized down there, and obviously some of the scandals that we're all familiar with illustrate that. So the evidence is that the system is not working very well in the city of New York and the outlying areas. But I think if you look at the quality of the judges that we have historically here and presently, I think you have to be satisfied with the way the system's worked here. I don't think a different approach is going to significantly change the type of people we get as judges or the people who be interested in becoming judges. I mean, most of these judges are taking a significant pay cut when they become judges. We should appreciate that and recognize that they are sacrificing in order to become judges. They could be they're all qualified lawyers, they're experienced, they're capable, they've enjoyed success for the most part, practicing law. So it's no small concession for a practicing lawyer to become a judge, because a lot changes in their lives. They certainly lose some of the independence that they had as practicing lawyers. They're subject to much closer scrutiny, and they're taking an economic hit.
Stewart, you've had so many opportunities to impact positively the legal system in and around the state of New York, but I note that you're routinely involved in supporting not-for-profit causes and community efforts throughout the Capital Region as well. And I think that all of us owe you a great debt of gratitude for doing that as well and promoting our community even outside of the courthouse as well. And I know there are some very significant efforts that you've recently done, and I didn't know if you wanted to mention any of those that you've taken so special care for recently in that way.
Well, I've been very lucky. Life has been good to me. I've been blessed in many ways, and I believe I should give back. I have a particular interest in cancer, in education, and in my church, the Catholic Church. I devote a great deal of time to advancing those causes, and believe I should. I believe it's an obligation that I have. I believe those of us who have had the good fortune to succeed should do something with the success we've had in helping those who are less fortunate. Cancer's touched my life very personally with the loss of Penny, and I have really thrown myself into that cause in as many different ways as I can. Education has been very good to me and my children, and I believe it's critically relevant to the success that I've had and that my children are enjoying. So I think people should have the opportunities that I've had, and I fund scholarships in a very substantial way at different educational institutions that I am connected to. So I'm in a position where I can help, and I feel an obligation to do so. I don't expect anything back for it. I just feel better having done it, and I hope that will last beyond my lifetime.
Well, certainly the entire Capital Region has benefited by your presence, and we're also proud here in the town of Colonie to call you our own.
Yeah.
And I want to thank you very much.
Good place to live and be. So
Well,
thank you.
Thank you for taking the time out of your busy schedule to join me today. I'm Judge Peter Crummey, and thank you for joining me on Benchmark.
Welcome to Channel 17, the Town of Colonie Government Channel.